Hello, hello, hello to all my pickles and picklettes. This is your number one absolute, unquestionable, favorite, racist cult leader speaking. This is video number 5 of the Contract Killer Course version 3.0. I have my Ace Ventura Pet Detective Special Edition button-up shirt on, as well as my "if I paid taxes, I would be in prison" hat, with the One Stupid Fuck logo on the side and the lanyard across the front. A beautiful addition to your wardrobe. Available in the store at www.onestupidfuck.com. But wait! You can also access the same website by using www.myfaceisachair.com, and you also can use the brand new URL, of which is the one I'm most excited about, covers me in the most depth of what I'm all about, www.racistcultleader.com. Buy today! All right, this video today, we're going to be covering taxes. And I'm so much happier doing this after doing negotiable instruments, because in 2.0 we didn't do that, which is a huge problem, because that's really the most important aspect of everything. But we're going to be going through definitions, we're going to go through the forms, we're going to go through statutory elements. The negotiable instruments part is just going to be a small part of this, because it's really just the crux of the whole thing, really. Negotiable instruments is the most important aspect to taxation. It's also the most important aspect to anything involving anything financial. Okay? So this is the tax code. Title 26 is the tax code, the Internal Revenue Code, the IRC. You can see that by going to tax code, scrolling down, look at all these glorious titles. Title 26, Internal Revenue Code. Okay? So, first thing we're going to do is we're going to hit up some defs. Okay? Definition number 1, you've already acclimated yourself to this fuckery. We've got the term person shall be construed to mean and include an individual, a trust, estate, partnership, association, company, or corporation. We've already covered the word individual can include legal fictions. The word individual, really, in a nutshell, is any man, woman, child, or legal fiction with rights and obligations under the 14th Amendment, which some people will say includes all non-whites. Some people will say it only includes blacks that were actually in slavery and then released after slavery. So, you know, you can kind of push whatever you want on that and just kind of see what happens. Depending on how good you are with your court procedure and stuff will determine your case and the way your case goes. We have here the definition of United States, same one from the Constitutional versus 14th Amendment flowchart. The term United States, when used in a geographical sense, includes only the states and the District of Columbia. So we need to find out what is the states. The states are right here below this. Number 10, A10. The term state shall be construed to include the District of Columbia where such construction is necessary to carry out provisions of this title. So the word state means the District of Columbia, and the word United States means the District of Columbia, okay? But in actuality, if you want to make this simpler, as far as I'm concerned, the term United States actually would be the better definition would be the one from 18 U.S.C. 5. This is actually a very clear, better definition of what they're actually trying to define. The term United States, as used in this title in a territorial sense, includes all places and waters, continental or insular, subject to the jurisdiction of the federal government. And then this was gone in 1999. It's not relevant. So So any place under the exclusive territorial jurisdiction of the federal government would be a much better usage here. But if you want to beat up the bar cards and beat up the IRS, you're more than welcome to just use this as it is, pure, and not even give them that much leeway. Just tell them it's only the District of Columbia and that's it. Fuck you. You could do that, not a problem. But I just don't really think that's the actual definition. If I had to redefine the word state, it would be any area considered separate that's still within the exclusive territorial jurisdiction of the United States. So the states are all listed under Title 48. So, for example, it wouldn't include Alaska and Hawaii because those were converted into sovereign states of the Union under the Republic side. So it wouldn't include that. So the Philippine Islands possibly, or maybe part of the Philippine Islands would be included in the word state. Puerto Rico would definitely be a state. The Canal Zone was removed, so that wouldn't apply. And I don't know if the Philippine Islands would apply, and if it does, it might only be certain areas. You would need to go in here and check that. The U.S. Virgin Islands would be considered a state, in my opinion, if I were to redefine subsection A10. Guam, the Guano Islands, haven't heard of that one, but that's probably part of it. Samoa is an interesting one. American Samoa, I don't think technically would fall under this definition of the word state because they're not citizens. They're only nationals of the United States. I don't think they have a tax liability. But this is saying Samoa, not American Samoa. Might be different for Samoa than American Samoa. Tu'ula sounds like that's probably a state under the definition of the word state. Manua, Swains Island, Trust Territory of the Pacific Islands. Okay, Eastern Samoa, don't know what that is. That could be possibly a separate state under A10. Submerged lands. I've heard about this. There's some islands that are actually submerged underwater now that are technically part of our territory. So if you lived underwater, maybe in Atlantis in those areas, you would possibly fall under the definition of the word state. Under the tax code, you may have a tax liability in that case if you are swimming with the dolphins, okay? Northern Mariana Islands, Micronesia, Marshall Islands, Palau. These are all places that may or may not. Some of them, it's the whole area. Some of them, it's only part of the areas. Like, for example, when the Canal Zone was a U.S. territory, it was just a certain part of Panama and the Canal Zone. It wasn't the entire zone. So it was very, very specific what areas. It was like a certain amount of square footage or whatever on both sides of the canal up to a certain point was the legal canal zone. So if you were outside of that specific zone, then you wouldn't actually technically be inside of a state as per A10. Again, if you'd rather just keep it simple and beat them to death, the word state just means the District of Columbia. I'm not even 100% sure it would include all the other U.S. territories and insular possessions, but I'm pretty sure it would. I'm just saying that because if you're in Puerto Rico, whether you're white or not, and you start doing some of this stuff, I don't know what they're going to do. It's possible that they're going to still come for you, okay? And if they do, I would probably say they're probably right. Also, keep in mind the headquarters for the IRS is in Puerto Rico. That also kind of gives it away, right? So that's kind of how these two are defined. So again, if you want to give them a real hard time, you can just go with what's written here. But in real reality, I think 18 U.S.C. 5 is better for defining this one. And then state would just be any independent zone that's separate that would still fall under 18 U.S.C. 5. So that's how I would define these to make it simple. I think that's a better way of navigating this. So if you are white and you are in Puerto Rico, just fucking move. What the fuck's wrong with you? Why are you there? Right? So that is that one. And then we're also going to cover some other definitions here. Taxpayer. I know we've already covered that in the previous video. We're going to cover it again. The term taxpayer means any person. That's the A1 definition. You click on it. It'll show you the A1 definition. Subject to any internal revenue tax. So I'm not a taxpayer, And if I said I was under penalty of perjury, I would be committing a felony up to 1 year in prison. So people say, oh, I'm not a taxpayer, blah, 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 and they want to argue about it. I am. If I said I was a taxpayer, I would be going to prison. That would be a lie, and I know, because for perjury to happen, you have to know that you're lying. That's the part that's kind of hard to prove in a court of law, is intent and stuff like that. So I would be committing perjury if I said I was a taxpayer under penalty of perjury. I own a taxpayer. I am not a taxpayer myself, though. And if I said I was, prison. Okay? All sorts of goofiness here. If you care to look through all this, you are more than welcome to. Employee, this is the one I wanted to cover, but the one I wanted to cover is in 26 USC 3401C. Okay. Let's see here. Here it is. For the purposes of this chapter, so what that means is for the purposes of Chapter 24, Chapter 24 includes income tax collected at source, liability for tax. So like when you have a job and they're withholding your income, I hate that word. They're withholding the unconditional promises and orders to pay that your sole proprietorship is becoming the holder of, which that's how goofy all this is, right? It's all the information involving all of that. Because I know a lot of fucking bar cards and stuff, they always go, oh, sovereign citizens, they just pick up definitions from anywhere and use them anywhere. Yeah, it's kind of true. We kind of do that. I've gotten a lot better at not doing that. So just to be clear, this definition of employee covers that whole kind of money being taken out of your paycheck. Okay? But when you understand negotiable instruments, it's all just hilarious. You just start laughing uncontrollably and you fall on the ground and roll around gasping for breath. This is all just hilarious. And that's why I wanted to, in the 3.0 course, I wanted to cover negotiable instruments first, right? So for purposes of this chapter, meaning Chapter 24, meaning withholding from your job, the term employee includes an officer, employee, or elected official of the United States, a state. Again, this means District of Columbia, and this means District of Columbia. So let's reread it. We're going to remove those and replace them with the definitions. I think it's 18 U.S.C. 5, but we're just going to go with what they say. District of Columbia includes an officer, employee, or elected official of the District of Columbia, or any political subdivision thereof, or, here's a real shocker, or the District of Columbia, or any agency or instrumentality of any one or more of the foregoing. Okay, so agency or instrumentality would probably be, that might be kind of where they're talking about the other areas, Guam, Puerto Rico, Palau. They might be referring to that here. Again, I really do believe those areas do fall under all these different meanings and definitions, even though they're very vague. The term employee also includes an officer of a corporation. So it's and I know there's going to be the naysayers. They're going to be, oh, this is horseshit and blah blah. No. I'm going to piece this together. I've got a whole bunch of different areas proving this, and we're going to get them all pieced together. Now again, let's go back to presumptions. This is the federal version, but there's a version for your state as well. It's just simpler at the federal version, so I'm just going to show you the federal version. California has its own rules on how presumptions are handled. In a civil case, unless a federal statute or these rules provide otherwise, the party against whom a presumption is directed has the burden of producing evidence to rebut the presumption. So keep in mind, everything I'm going to cover in all these videos, including this one, it's like, here's circumstantial evidence. Here's another piece of circumstantial evidence. Here's another piece of circumstantial evidence. Here's another piece of circumstantial evidence. based upon these kind of loose maybe pieces that like no one wants to believe is true, I'm going to build a presumptive argument, and then now that shifts the burden of evidence over to them. So if you sued the IRS, you can take some of these things that seem too unbelievable to be believed, you can structure them all out in a presumptive cause of action or presumptive argument, and now the IRS is the one that has to prove that it's not true, which they're never going to do. They are fucked. So keep in mind, some of this stuff is so unbelievable that it might be hard for you to believe, but you don't need to worry about all that. All you got to do is just take what I teach you here, piece it together, and then make a presumptive argument out of it, either using Rule of Evidence 301, or if you're in a state case, you're going to use the state's version of the presumptive arguments. And that to me is a whole new way that we're able to fight these things in court. You don't the burden of evidence for you only exists up to a certain point, and then it can become presumptive, because the presumption has to be based on some prior underlying facts or ideas, right? So this would be fact number one to build the presumption that the word employee only applies to officers or elected officials working in the District of Columbia, the District of Columbia, or the District of Columbia. Okay. Make them prove it's not. Good luck. Right? Good luck, motherfucker. And some people will say the term employee also includes an officer of a corporation. They're referring to a domestic corporation, and then the word officer means one of the four executives. So keep in mind, not every single person in the company is an officer, and then when they say corporation, I have trusts, so it wouldn't even apply to this. And then also keep in mind, they're referring to corporations that are established under the United States or operating in the United States as a resident. So there's a little bit more to it than that, right? It's not just any corporation on the planet. It falls under that. That's stupid, right? Obviously, the whole point of everything, and I'll teach you in the trust video we're going to be doing, I think, next. Oh, no, a couple videos from now. A trust wouldn't be a corporation anyway, so it's kind of irrelevant. Just convert all your corporations into trusts. If you have a huge S corp, just get rid of it, take all the assets out of it, and then move all the assets into a trust, and then bang, like it's that easy. Then you're no longer underneath this. Easiest thing in the world, right? So, trade or business. We've already covered that. We're going to cover it again. It's so important. So here's item number 2, proving that, the term trade or business includes the performance of the functions of a public office. They're going to say includes, and then includes is actually in here as well, right? So I will show you, because they're the smart bar cards. I've never found one yet, but eventually we are going to run up against a smart bar card, maybe, probably, and they're going to find this. This is C, subsection C in the same area, includes and including. Never had a bar card find this, but one day, maybe they'll use AI or something and they'll find this and they'll have maybe 2 brain cells remaining. I mean, it's a very hopeful sentence, but we should be prepared for the possibility of the evolution of the mind of the bar cards far enough to be able to piece together a simple definition. Could happen. You never know. The dinosaurs never thought they'd be extinct, I'm sure, right? The terms includes and including, when used in a definition contained in this title, shall not be deemed to exclude other things otherwise within the meaning of the term defined. So this is easy to fight, guys. All you do is you say, well, it appears we have some legislative confusion. Let's go ahead and subpoena the people in the IRS and the legislators that are responsible for having written all this stuff, and let's ask them what they meant about this stuff. They will never do that. And a definition, by definition, has to be a limitation or boundaries of meaning. They can't just open it up to mean all this other stuff. So as far as I'm concerned, they have two choices. Either A, it doesn't mean this, and this is full of shit, or B, the definitions aren't really definitions, which basically obliterates all of Title 26. Because without definitions, there's no way to actually navigate any of this, and the whole thing just collapses. So either way, they're fucked. Because there are no they don't want to talk about any of this shit. No one wants to talk about any of this. So you just say, oh, good, okay, cool, that sounds good. Let's subpoena the legislators and get them in here so we can clarify all these different definitions. I've got several I want to talk about. Oh, God, right? So they'll freak out, and they'll try to settle if you're suing them, or they'll dump the case if you are the defendant. Okay? Super easy. Like I said, my platform is all offense. It's all being the plaintiff, and then we're designing an entire technology of finding out all the things they don't want to talk about, and then specializing in only talking about those things, and then just bashing their skull in with those things until we get what we want. It's a very simple overall thing. No one's ever built anything like this before, so I'm having to do it sort of by myself through the forest, which has been quite difficult. But now it's getting pretty fun. I'm having a lot of fun with it. So this is also proven, another piece of evidence that you can use Social Security Card 1936. This was the very, very first version of the Social Security Card. And if you look closely, the very, very, very first version from 1936 had the term employee's signature. They took that off real fast because people had a lot of questions. Think about this. People were getting Social Security that may not have been employed. So they're going in there, they don't really have a job, or maybe it's just a housewife or something. And they sign employee's signature. Employee of what? They took that off real fucking fast, right? Employee of what? Let me see here. Let's go to Grok. And let's ask Grok, where is the definition of employee in the Social Security Code in the USC or maybe CFR? I'm not sure. Any officer of a corporate, I'm not going to get into all this and try to dig into it and find out what it applies to. And we're just going to read this just as a loose thing and try to see what we've got. And then obviously you should go and actually double check to make sure this is correct. Definitions relating to employment. This comes from all sorts of stuff. But it is Social Security, I can tell, because it has that term, old age survivors, whatever. This one here is one of the main trust accounts that are in, you see here, trust funds. Yeah, here's the trust funds, the main trust funds that are under the Social Security, the Federal Old Age Survivors, and the Federal Disability Insurance Trust Fund, and has all this information about all that, right? So, wages defined, that's kind of interesting, right? Anyways, so definitions relating to employment, let's go down to... When you start seeing these really, really long, complicated definitions, you already know... There's probably something there worth looking at. No one else wants to fucking talk about any of this shit either. So all you got to do is just be like, let's talk about the definition of employment from subsection A. And they just freak out and they run. So you can use all this chaos and confusion to your advantage. Okay. Let's see here. Oh, it's subsection J. Let's just scoot down there real quick. Any officer of a corporation, any officer of, here it is. We already see here, look at this, United States, when used in a geographical sense, means the states, which I'm sure is defined. Yeah, see, look at this. See the definition of the word state? So you already know we're getting into some goofiness when you see a definition like this, okay? In a hospital, home, or other institution by a patient or an employee of a state, or this is probably how the whole birth certificate thing works right here. They presume that you are a employee of a state or political subdivision and you're in a hospital, home, or other institution and you're a patient. See that? We start getting into kind of all this stuff, right? But obviously you see this definition of state and you're like, all right, something goofy's here. Yeah, exactly. So you can almost just remove that because they're not going to want to talk about that definition. So if they don't want to talk about it, it doesn't exist. You see that? It's easy. So if we just remove that, the term United States, when used in geographical sense, means the District of Columbia, the Commonwealth of Puerto Rico, Virgin Islands, Guam, and American Samoa. See, that makes more sense. See? Now we have the definition of employee, any officer of a corporation. Corporation has a special definition. You can attack that. Any individual who, under the usual common law rules applicable in determining employer-employee relationship, has the status of an employee. This one is probably the one that they use for most of this stuff in our jobs and stuff like that. So there you go. But again, it'd be all these different employments within the United States. District of Columbia, Puerto Rico, Virgin Islands, Guam, American Samoa. They have exclusive territorial jurisdiction. They have full. They literally own, like how we used to own slaves, how the white man used to own black men as slaves and they were just full-blown property like a desk or like a phone. That's how the federal government owns the U.S. territories and insular possessions. It's not like the 50 states where we're all kind of equal and we all kind of have our own separate legal zones and we're all kind of sovereign. No, these are properties. These are owned properties of the federal government. So keep that in mind when you're looking at all this stuff, right? But you have employee's signature. Employee of what? Employee of the federal government. You have that here on employee. You have that here on the term trade or business. And the other thing you can look at is 26 U.S.C. 162. Like I said before, trade or business expenses. If you go down and read this whole page, it's all only involving public office. So again, we're building out the presumptive argument to shift the burden of evidence over to the IRS to prove that this definition of trade or business includes other things besides public office. And you see, we've already got 3 or 4 pieces to build that presumptive argument. They're cooked. They are so fucking cooked, it's unbelievable. They can't prove that. Okay? So it's not, the burden is not entirely on you. It's on you up to a certain point, and then you can convert it into a presumptive argument. Okay? So here's another piece. So you guys get these letters in the mail that they're going to do a levy or a lien. You see a lot of these levy and lien type letters that they send. So 26 U.S.C. 6331. If any person, which is the 26 U.S.C. 7701 subsection A1 definition, liable to pay any tax, neglects or refuses to pay the same within 10 days after notice and demand, it shall be lawful for the secretary to collect such tax by levy upon all property and rights to property belonging to such person or on which there is a lien provided in this chapter for the payment of such tax. Levy may be made upon the accrued salary or wages of any officer, employee, or elected official of the United States, which means the District of Columbia, the District of Columbia, or any agency or instrumentality of the District of Columbia or the District of Columbia by serving a notice of levy on the employer. This is what you guys are getting when you guys get these notice of levies, all this kind of stuff. So the first question is, we've got trade or business, we've got definition of employee, we've got this thing here, levy, we've got the definition of United States, the definition of the word state, plus you can use 4 U.S.C. 71, 4 U.S.C. 72, all the stuff from the previous videos. You're going to build out a presumptive argument. I'm not even sure you need a presumptive at this point, but you can do it that way. And then now they're the ones saddled with having to prove that it's not. And they don't want to talk about any of this shit. That's the beauty. They don't want to talk about any of this shit. By the way, let's do this. How many audits per year does the IRS file, and how many lawsuits do they file? What is the ratio between audit and lawsuit? I use SuperGrok, by the way. I have a paid version of X because it also lets me have more exposure on X. It allows me to post longer posts. There's a bunch of other positive aspects to having a paid version of X. I pay for all social medias except like TikTok because I don't even know why I even have TikTok. I really dislike the platform. I think you should have to prove that you have an IQ lower than like 69 to even get on there. LinkedIn too is also horrific, but Instagram I pay because I want that blue check mark. X I pay because I want SuperGrok, and I want SuperGrok is what I've been using for all of my research. I don't use any other AIs. I don't care to even try to learn anything else. I've tried a few in the past. I didn't like them very much. I don't want to spend all the time trying to learn how to use them. So I was just kind of waiting for one that would just be able to work with me as an idiot. And SuperGrok was the first one that I was able to work with as an idiot. And I've been able to work with as an idiot ever since. And I just don't care to try to do all the crazy stuff that people do with all the programming and all the craziness. So I like SuperGrok a lot. I'm very pleased with it. And it has helped me. I use it mainly to find me cases, find me quotes, to do historical research. Like this happened and then what happened after that, and then what can you show me to source that, and blah, 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 blah. I do a lot of that kind of stuff. Not a lot, but I do some with it. So let's just pretend as though this is accurate information. I don't really think there'd be any real reason why it wouldn't give me. So here we go. So 505,500 tax return audits in 2024, and 500 to 600 lawsuits. So everyone is scared. This is roughly half of the level from a decade earlier. So a decade. And then now it's going to be even less because everyone's pissed off. They're getting hit from every direction. Trump's suing them, everything else, right? So there's 23,000 to 24,000 petitions per year in the U.S. tax court, but the U.S. tax court is their court. It's not even, it's an administrative court. It's an Article I court. If you do a little bit of research, and you'll see later when we go over my litigation flowchart, tax court's not even really like a real court. So anyone who's ever gone into a tax court is a complete idiot. You never go. Why would you go to a tax court? That's like their own private administrative court. They're not going to let you win. It's not. It doesn't. The rules don't apply. So that's all irrelevant. You can just ignore that. So 505,514 audits and only 500 to 600 civil suits. So what is that? It's like 1/100th of a single percent. What is that? One lawsuit for every 1,000 audits. Yeah. That's because it's all horse shit, guys. They don't want to talk about any of this shit in the courts. They're terrified of talking about any of this shit in the courts. So people are all scared of the boogeyman, and it's just like, dude, the boogeyman is a fucking joke. I literally have on all my social media profiles, my tagline on everything is, if I paid taxes, I'd be in prison. There is nobody on this planet except, like, I don't know, Dave Champion or somebody who's more vocally not paying taxes than I am. It's a joke, dude. Okay? So, with that said, let's move on to the next section here. There's this thing called the revocation of election that's been floating around for a long time. I recommended it for a long time. I even recommended it in the 2.0 course. And I got rid of it in December of 2024 when I realized everything was the sole prop. That's when I got rid of it. And this is actually the spot where I had a monstrous realization on the subject. So there's this whole idea that you elect to pay taxes. But let's reread this again. I know I read this before. If any citizen or resident of the United States does not reside in, is not found in any United States or District of Columbia judicial district, such citizen or resident shall be treated as residing in the District of Columbia for purposes of any provision of this title relating to jurisdiction of courts or enforcement of summons. That's just saying for USC 72 and the exact same thing. All offices attached to the seat of government shall be exercised in the District of Columbia and not elsewhere except as otherwise expressly provided by law. Attach this in. Trade or business is involving public office. Employee is officer of the United States. Do you see it? Do you see it? It's all revolving around working for the government. Government employee. A government citizen is a government employee. That government citizen or government employee, the citizenship of that government employee is attached to the District of Columbia, not a state of the Union. Not a white citizen of a state has his citizenship attached to a state of the Union, California, Utah, Texas. A federal citizen has their citizenship attached to the District of Columbia. So no matter where they are, they're residents. And if we want to drag their ass back home, we can do so any time we want. And that's when I realized, oh, fuck. And I had my own revocation of election document that I had spent, dozens and dozens and dozens of hours on redoing it and updating it. I had to throw it out the fucking nearest window. It was painful. It was painful. Tons and tons and tons and tons of work went into this revocation of election, and I had to just toss the whole thing. It's been gone ever since. If anyone has my old revocation of election documents, you have to get rid of them, because if you keep sharing that stuff, you're just harming people, really, because I didn't realize at the time it's just not applicable at all. It's not realistic at all. And it doesn't matter either, because I've already figured out all new stuff. It's way better. We're going to cover everything in this video in great detail, so don't worry too much about it. You don't need to worry about any of that shit, okay? So let's start getting into some of the tax forms. So tax forms, right? So first and foremost, we're going to get into the Internal Revenue Manual, the IRM, okay? And if you go to the IRM, you can see here irs.gov/IRM/part 21/ and then we have the actual Internal Revenue Manual. So the IRC, which is Title 26, that deals with like the overall laws. And then the IRM, the Internal Revenue Manual, deals with internal administrative activities. This is how the inside of the IRS operates. It's different from the IRC. This is almost like the employee manual, basically, kind of. But it's like the public has a right to know how the IRS works. This is the internal workings of the IRS. So we have here the definitions of a domestic corporation, partnership, or disregarded entity, right? So this is another piece of the pie that proves that a disregarded entity that is created or organized in the United States or under the laws of the United States. This also proves that the sole proprietorship was born in the District of Columbia. So it is a domestic corporation, partnership, or disregarded entity. And the disregarded entity is also called a business entity. You see that? It's a business. It says it's a business, and then they go, oh, but it's not incorporated. I'm not a business, bro. Are you a business? Again, what are the two big questions about the sole prop? I don't know if I covered the second question. Question number one is, where the fuck did this thing come from? You want to talk about a question no one wants to talk about? You want to talk a question that will get the entire DOJ to scream and hang themselves? Where did this thing come from? Where did it come from? I'm truly curious. I'm not even mad. I just want to know. You might as well set the building on fire. Same thing. They're never gonna answer that. Second question is, I'm not a business. You calling me a business? Sole prop is a business. It's an entity, which means business or legal fiction. Business entity. Am I an entity? Am I a business? So where did this thing come from? And why you call me a business? It's like the redneck version. I'm from Indiana, man. It's like the redneck version. It's like, where'd this thing come from? I have a business. I'm not a business. You call me a business? Like, it could be literally that easy because they don't want to talk about any of this. You're getting down into the heart of death with this kind of stuff, right? So, foreign just means outside of the United States, which means outside of District of Columbia or any area, as far as I'm concerned, any area under the exclusive territorial jurisdiction, U.S. territories and insular possessions, the things that they own, right? So you can see here, foreign trust means any trust other than a domestic trust. That's what we build. We build foreign trusts. And a lot of people in the sovereignty space, they'll say estate. The all caps name is an estate. That's also complex because if you say estate, now you have to have a bar card because you can't represent your own estate. That's why I don't use the word estate. That's why I don't use the word trust. I use the terms disregarded entity. All of a sudden, they've got no problem with you being there when you say that, or sole proprietorship. And I am living proof that when you start saying that, they've got no problem with you being there. Okay? So if you want to say estate, you're going to learn the hard way. You're going to spend months and months and months. You're going to waste your time. And then you're going to come back and say, Brendan, you were right. I should have said sole prop. I would have saved 6 months. I'm going to say, I get it. Some people just have to do that to learn. And then if you say trust, Sesta KV trust, any of this kind of terminology, you're going to go down that path. You're going to spend 6 months. You're going to get your ass beaten to death. You're going to think that the judges and the courts are all baby killing, whatever, drinking the blood of whatever, because you fucked up and you spent all your time talking about something that they're going to force you to have to get a bar card to represent in court, okay? If you say disregarded entity, if you say sole proprietorship, I am living proof. I am all the way in the U.S. Supreme Court as of fucking last week, ladies and gentlemen. I have done this in state court in California. I have done this in district court in California, the Ninth Circuit. I have gone to the Ninth Circuit Court of Appeals 2 times doing this, once in the SBA case and once in the Amex case, and Now I'm in the fucking U.S. Supreme Court, all under the sole prop. No one's had a fucking issue with it. When the Supreme Court got their hands on it, one for one, it takes them 2 to 3 weeks to evaluate a writ of certiorari and send it back with updates. They had mine for 5 months. I was going to fly out there to figure out what the fuck was going on. And I didn't have to because they finally sent it back to me. And I guarantee you, the reason why they had it for 5 months is because they've never seen anyone come all the way up to the Supreme Court as a white state citizen representing a sole proprietorship. And guess what? They had no problem with it. So if you want to use it and you have any issues, just show them the docketed Brandon Joe Williams registered trademark v. Small Business Administration. And you just say, just file that into your court case and say, they docketed this, Your Honor. See that? I'm here for you, my nigga. Don't worry. So going down, we have. I'm not going to get into the 98s because the thing is, we file all the time for foreign trusts. We use 123 Purple Monkey Lane. We do all sorts of craziness, and they don't give us 98s. And I've just never seen anyone actually have an issue with this stuff. I've never seen anyone go into court. The IRS never sues anybody, so you don't even need to worry about it. But I've just never seen the IRS try to sue someone, and then there was an argument over tax ID numbers. I've never seen it. So for a long time, I was like, how do I figure this out? How do I figure this out? How do I figure this out? And then as I learned more and more about the numbers and the number of audits and the number of court cases and stuff, I just realized it's a problem that a lot of people are trying to solve that just doesn't really need a solution, guys. People put a lot of work into this whole 98 number thing. It's just never been an issue. I have a 90, bunch of different numbers for all sorts of trusts and stuff like that. I just say foreign trust on everything. I've never had an issue. So if the day comes where they say, oh, no, it's not foreign, it doesn't have a 98, we'll get into it. I don't mind getting into it. There's also on the form to get an EIN number form, is it an SS5 form? No, that's the Social Security application to get a Social Security number. SS4 form. Right, here we go. So this is the form to get an EIN number, right? We're going to cover this in more detail on the trust. Let me just make sure I have that note here on the trust. Yeah, getting an EIN number. I've got it on my trust video, right? So we're not going to get into that too much now. But you can see here. This is also another piece of evidence that you can see that the sole proprietorship is actually the thing that has the SSN, not you. And again, the sole proprietorship is a business entity. Are you a business? Are you an entity? Okay. Then that means you do not have a Social Security number. You never did. And if you keep telling people you do, you're a fucking liar. And if you do it under penalty of perjury, you should be behind fucking bars. I hope it's clear. The Social Security number is a taxpayer identifying number for your business of which you own, called a sole proprietorship. You are not a taxpayer, as per 26 U.S.C. 7701 subsection A14. So how would you have an identifying number for something of which you are not a taxpayer? That's all perjury. You'd have to know for it to be perjury. So now that you know, now it's perjury. I forget why I pulled this up. Let me see here. I totally forgot why I pulled this up, right? Anyways, so let me pause this. I don't know where I'm at. Let me pause this. All right, so that's how the revocation of election is horse shit. All these people are running around talking about revocation of election. I was too for a long time. Ignore it. All these things are a waste of time. State national is a waste of time. Revocation of election is a waste of time. Cesta KV trust is a waste of time. 1099A forms with the IRS is a waste of time. Exclusive equity, waste of time. There are so many things in the sovereignty space that I had to go into and do a bunch of work with and do a bunch of analysis and do a bunch of fucking things and rewrite documents and rewrite revocations of election and do all this stuff to one day wake up and realize it was all a complete fucking waste of time. So the 3.0 course is just that next layer of me telling you what I've found is a waste of time and what's not. All the passport stuff, the 4 and 5 star, that's all a waste of time. It's got nothing to do with you. You never had a passport. No one listening to the 3.0 course has ever had a passport. I've never had a passport. If I told someone I had a passport under penalty of perjury, I should be getting fucked in the ass in a prison cell. I don't have a fucking passport. I've never fucking had one. I don't qualify to even have one. I've never had a social security number. I don't qualify to get one. If I told you I had one, I'd be in fucking prison. I'm not a fucking taxpayer. If I told you I was, I'd be going to prison if it was under penalty of perjury. I've never had a driver's license. If I told you I had one, I'd be going to prison under penalty of perjury. I don't even qualify to even fucking have one because you have to prove that you're a resident. Do you see that? People in the sovereignty space, oh, you don't need a driver's license. You have the right to drive. You can't even fucking get one. Oh, you can just revoke your election to pay taxes. If I paid taxes, I'd be in fucking prison. When you understand the laws, it's not this like you can do whatever you want. You can just say you're not a citizen. That's not how it works. If you say you're not a citizen, you instantaneously would just become a resident. A lot of people are like, oh, I'm not a U.S. citizen. I'm just going to say that. Okay, fine. If you say I'm not a U.S. citizen and you don't clearly communicate that you were born a white citizen of Indiana and now I am a white citizen of California due to a change in domicile, and I have absolutely no rights or privileges under the 14th Amendment in accordance with Bradwell v. State, where Mr. Miller talks the day after the fucking slaughterhouse cases. If you don't say it all, you default to a resident. Okay, fine. So he's a resident. Residents and U.S. citizens are treated the same way. They're both under the 14th Amendment. It's the same class. And that's why you see here, it was like the 150th time that I had read this and finally so many things clicked into place when I read this. And this was the huge monster breakthrough point when the whole sole prop thing came in and all the other stuff and doing all this stuff. And then that's when the passport started to become, because I used to do the passport explanatory statement used to be about us. Huge mistake. That was all thrown out. I had to rewrite the whole explanatory statement. It's all for the sole prop. White citizen of a state getting a passport on behalf of a sole proprietorship that is a U.S. citizen. That's when all that stuff started. Okay. I had to get rid of the revocation of election, a lot of stuff. And that was actually after the 2.0 course. The 2.0 course was in July of 24. A lot of these kinds of realizations were in December of 24. And that's why, I'm glad I'm finally getting around to doing this 3.0 course, because a lot of the earlier information in 2.0 is all gone, right? So we're going to get that all cleaned up here in 3.0. I don't think any of this stuff's going to change any farther from 3.0 because now it's all based off case law. 2.0 wasn't necessarily based off case law. I didn't really start getting heavy into case law until 25. All of 2025 was me really deep in case law. I was pretty much just reading cases the whole year, honestly. So everything's a lot more tied down now than it used to be. I don't think we're going to be seeing any more major changes with a lot of this stuff, but I just don't know. Wherever, if you would have told me 2 years ago I'd be running around talking about white people, I would have thought you're fucking crazy. So I don't know. I mean, so at this point, we're going to cover the various tax forms. So let's go through the tax forms. I wanted to show you, this is the small claims for California. It's an SC 100. I'll probably cover this more when we get into litigation and stuff like that. But whenever you have any issues with anybody, including the IRS, you don't repeat yourself over and over and over again and get upset. Most of my job, if you really want to boil it down, is to help you guys manage your emotions. That's really what I'm good at. That's really what I specialize in. That's something you don't really see anywhere else in the sovereignty movement. So you don't get mad. You don't get upset. You say something once. If you have to repeat yourself maybe one more time, and in the second letter, you're going to say, hey, if you keep bothering me, it's going to be harassment, and we're going to do small claims. And then at that point, you're just going to pay $80. You're going to fill out this form. It's super easy. You just fill out the plaintiff, the defendant, and why does the defendant owe the plaintiff money? You would just say harassment after already being warned and already being given the information required. And you just make up a number. $1,500. You can say in your original letter how much it's going to be, and it'll be you just tell them straight up, tell the IRS, if you guys mail me again, it's going to be $1,500. I'll be filing in California Small Claims Court using an SC 100, and the literal claim is going to be, quote, harassment after already being warned and already being given the information required. It's sort of like a fee schedule, because I know a lot of people talk about that in the sovereignty movement. I'm not a big fan of the whole fee schedule thing. I think you should just be very specific. Like, they send you a letter, you respond to it, you give them all the information they need. They send you another one. Maybe by that point, you're going to tell them straight up if they send you anything else, it's going to be X amount, and it's going to be the exact wording of how your small claims case is going to be. And you're just going to put in here the defendant is going to be Internal Revenue Service. Put their phone number, put their information. And when did this happen? How did you calculate the money owed to you? Informed them contractually that I will be filing this if additional harassment takes place due to a failure for them to do their job. Whatever, right? But this is super, super easy. Now, you may not win this case, but it costs $80. It's super easy to put together. You don't sit at home worried and angry. The IRS controls people by being really poor communicators. You got to wait on hold 8 hours to talk to them. When you do talk to them, they have no idea about anything. You start bringing up any of this information and they just hang up on you immediately. That's also very common from what I've been told. You don't play the game in their court. You drag the game into your court. And if they don't want to talk in your court, then you win. If they don't show up, you just made $1,500. If they show up, you better show up to fucking talk, motherfucker. Because if you think you're going to show up and not talk, now you got to talk. Fuck you. I'm not waiting on hold to talk to you for 8 fucking hours. You fucking faggot. I'm dragging you into my shit. You bring your fucking notes. I'll see you in 28 days. Fuck you. You call me again, it's going to be a second case. You call me again, I'm suing you a third time. And then obviously if you want to go into big boy court, that's even better, but this is easy, guys. You don't get emotional. You don't wait on hold for 8 hours. You don't wait for them to message you. You don't let them send you horseshit letters. If you get upset, you just sue them. It's the easiest thing in the world. Even if you don't win, I can pretty much guarantee you they're going to stop talking to you. So even if you don't win, you still win. And we're going to be covering that later in the course. I have never won. People always say, oh, Brandon's never won any of his court cases. It depends on how you define win. I'm winning all over the place. I'm learning all this stuff. Amex says I owe them $177,000. They're not knocking on my fucking door. SBA says that I owe them $198,000. They're not knocking on my fucking door. IRS says I owe them $9,000. They're still sending me bills like once a year. I might drag them into small claims myself if they don't fuck off with that bullshit. So, who's really winning? I'm the one suing everybody. No one will talk to me. I'm the plaintiff in every single fucking case. You can go and search my name as of this date. I pray every day. When I go into hearings, I pray. I literally have wet dreams of being served a civil suit at the courthouse when I'm there for my hearings. I literally dream about it and practically nut myself while I'm sleeping. Never happens. Because finding me is a bit difficult. My information is not really readily available in most places. So a process server would have to wait until I'm kind of in some kind of a public zone, which the best place to find me would be when I go to my hearings. So I always think to myself, if someone is going to serve me something, it's going to be at one of my hearings. Never happens. So people say I've never won a case. I still have my Amex case in the Ninth Circuit Court of Appeals going right now. I've got my writ of certiorari for the SBA case. Most likely that's going to get denied. Let's just be honest. It's my first time up the bat, though. To me, it's a huge win just being there. 99.5 to 99.9% of all attorneys never file a writ of certiorari in their entire career. One stupid fuck, the greatest racist cult leader that has ever walked the earth without any fucking legal background and without being a member of the bar, did it in 2 years from when he started. I started in January. Well, fuck no. Oh, wait. I started in January of 24. So, no, that's a year and 4 months. A year and 5 months. And it took him 6 months to look over the goddamn thing. Is that right? Holy shit. So I actually went to the Supreme Court. When I first filed that writ of certiorari, it was actually in October of 25. Oh, wait. Oh, no. Yeah, 2 years. No, what am I thinking? Oh, my Lord. 2 years. So 2 years, 4 months to now. But when I originally filed the writ of certiorari, had they not taken 5 fucking faggot months to look at it, it would have been a year and a half. A year and 9 months. So a year and 9 months from literal styrofoam helmet retard doesn't even know how to file a complaint to start a lawsuit, all the way to the Supreme Court with zero formal training in 1 year, 9 months. And I literally have a website called racistcultleader.com. How fucking cool is that, bro? God, it's fucking awesome. I am the best racist fucking cult leader, dude. I swear to God. So anyways, emotions are the key, guys. So a lot of 3.0 is all about controlling these negative emotions. We're going to be getting into that a lot more later in the course when we start getting into the flow line of litigation and how to kind of set yourself up mentally. That's something that I think is really unique that I talk about that no one else really talks about, right? So you're not going to hold. You're not going to be waiting on hold. You're not going to be writing back and forth with people who are very vague and they just write you scary stuff. You're not going to be scared about levies and liens. You're not going to be doing any of this stuff. You're going to be communicating one time, clearly, calmly, and in a friendly manner. You're going to communicate maybe a second time. That one's going to be a little more firm. And you're going to say, hey, either we're going to have a conversation about some of these things or we're going to small claims court for various claims, various amounts. And then if there's any additional communication after that, it's just bang, $80, small claims case. I'll see you in court, motherfucker. You're going to wait 28 days to talk to me. Fuck you. You see the difference? Wait on hold for 8 hours. You got to be fucking kidding me. Waiting on hold for 6 minutes. You can go fuck yourself. Waiting on hold for 6 hours. I saw a guy the other day, I saw a press release about a guy where all he does is people pay him to wait on hold for them, and he makes like $140,000 a year. What kind of fucking simp, piece of shit, non-American faggot pays someone money, negotiable instruments, unconditional promises to pay, to wait on hold to speak with the IRS? Why don't you just stick your dick in like a fucking wood chipper? Why don't you just stick your dick in like a cucumber slicer? How pathetic you gotta get. No, bitch, I'm not waiting for anybody. You're gonna wait for me, and you better have your shit straight at the fucking hearing, or else I just made $1,500. Fuck you. Do you see the difference? And if you really want to scare the fuck out of them, then you file a big boy state case, and then you get into discovery and you start asking a lot of questions. Then you're going to have dead bodies on your hands, literally dead bodies. People are going to quit, kill themselves. Okay, but this is the easy. If you want the easy, this is the easy. I'm just showing you the easy now. You could be literally retarded and not even have a computer. And you can go into the courthouse and you can get an SC-100 or whatever. You can fill it out with a pen, and you can literally pay probably with cash, $80, and you've got yourself your hearing. I think they stamp the hearing date literally on the document when they process it. You don't even need a fucking computer. You don't need any logins. You don't even need a credit card. You literally don't even need to hardly even know what most of the terms mean on the form. Name of plaintiff, name of defendant. Why do they owe you money? When did it happen? Yes, if you didn't do this, just check this out before you do all that. Why are you filing this? It's where it happened, where the plaintiff was injured. Is it an attorney-client? No. Are you suing a public utility? I don't know. You need to look up and see if the IRS is considered a public utility. You could try that. I don't know. Have you filed more than 12 other small? Nope. Is your claim for more than $2,500? It depends on what you're asking for. You can only do 2 small claims cases for more than $2,500 during a calendar year, but I believe you can do as many as you want below $2,500. So you can't get a hold of your gas company. They won't respond to anything. This, whatever it is, you can just $2,500 all day long, all year long. You can just do 25 hundos over and over and over and over. But if you want to do more than 25 hundo, you can only do 2 per year. I understand that you have no right to an appeal, and then you just sign the fucking thing. And if you want to do sole prop, you can do sole prop over here. Plaintiff name, you can do if you don't like the idea of being the actual plaintiff, it'd be like this. Or if you wanted to be even more esoteric, if you want to be more of a fucking, you could do disregarded entity. You could do that. And then here you would do without prejudice. And then you would do by Brandon Joe Williams, comma, owner. That's how I did mine, I think. I have all the documentation for this on my case, previous and current litigation page. So if you want to go and look at what these look like, you can probably find them in the uscourts.org, all the court system and everything too. So it's not just my stuff. But anyways, I wanted to show you that. Dealing with the IRS, you shouldn't let them lead you on and get you emotional, and you shouldn't let them be bad communicators. They should be punished incessantly for being bad communicators. And if you really want to punish them, you file in state court. But small claims is fine, right? If you file in state court, they'll probably try to remove it to federal court. That's a whole other thing. I don't think they can do that with small claims. It may require a little bit more research to really do that, but anyways, that's what I would do. Fuck it. I would $80. Worst thing that can happen is you lose $80, but they're going to know that you're not fucking around. So, just to be taken seriously, it's worth $80, right? That's the way I look at all my litigation. Everybody takes me fucking serious now. It's like now nobody wants to fuck with me, or nobody laughs at me anymore. And it's like, did I really lose? I'm 400K up. I don't pay taxes. I have no driver's license. I have no registration. I don't even smog my car. In California, they have smog, which is like the emissions testing. You don't have that. So did I really lose these cases? Am I really a loser? Am I really losing these cases? I don't think so, but fine. You can say whatever you want, fine with me. And another thing that I say a lot too is you only lose until you win. I might lose 10 more cases. You only lose until you win. Just a matter of time. So let's get into these different forms. We're going to get into the different forms. So here is the W-9 form. This is the one that you typically sign when you start a job for the first time. Okay. So look at this. Name of entity / individual. An entry is required for a sole proprietor or disregarded entity. Enter the owner's name on line 1 and then the business / disregarded entity's name on line 2. Now keep in mind, if you're going to fill this out, you're filling it out on behalf of a U.S. citizen or resident, which would be a taxpayer. You see that? So you ask me, well, Brandon, how would I fill this out without being a taxpayer? You really can't. You can't fill out this one if you don't want to be if you're not a taxpayer, right? Certification under penalties of perjury, that's up to 1 year in prison. That is a felony. Number 3, I am a U.S. citizen or other U.S. person defined below. And then you see here signature of U.S. person. If you're a white citizen of a state, you aren't a U.S. person. So why are you signing this? And then you say, oh, I have to sign it to get a job. You can use small claims for that too. $5,000 for employment, whatever. Employment discrimination, because they tried to force you to fill out a form that you legally cannot fill out. They tried to force you into committing a felony, and because you didn't commit a felony, they wouldn't hire you. Just take them to small claims. Easiest thing in the world. I've been waiting for somebody to go along and just start filling out job applications and just start suing everybody, making like $50,000 a month, just suing companies because they force you to fill out W-9s and I-9s. If anybody out there ever does that, please contact me. You are basically my hero. I would like to maybe bring you on my show or at least speak to you in more detail. So here's a definition of a U.S. person. An individual who is a U.S. citizen or U.S. resident alien. So an illegal alien would also fit in this category, because an illegal alien, as per Plyer v. Doe, which is at the very end of my timeline on the Constitutional versus 14th Amendment flowchart, is under the 14th Amendment. So both of these classes are under the same 14th Amendment class. A partnership, corporation, company, or association created or organized in the United States or under the laws of the United States. Again, that is the District of Columbia. So created or organized in the District of Columbia or under the laws of the District of Columbia. An estate other than a foreign estate, or a domestic trust, which wouldn't include a foreign trust. So your foreign trusts would not be able to fill out W-9s. And you, as a white citizen of a state, would not be able to fill out a W-9. If you do fill out a W-9, you're going to prison. Why would you commit perjury when you could just sue them and get paid because they're trying to force you to do something that legally you can't do? Simple, right? Here's your W-4. The big hot new thing now everyone's doing is they're going exempt on their W-4. The word exempt, let's see if we can find this rapidly. Legal definition of the word exempt. Whoopsies. Legal here we go. Let's see if we can find a legal. Let's see here. Legal definition of exempt. If not, I will pull it up. So this is the definition that I remember actually from the, oh, here we go. Let's see. Man, I'm going to pause the video for a moment here. So here's a definition of exemption from Black's Law 4th edition. Freedom from a general duty or service. Immunity from a general burden, tax, or charge. A privilege allowed by law to a judgment debtor. Let's see here. So if you go deeper and deeper and deeper into the definition of exemption, I'm just going to close this. Exemption is what you see here. It's freed from a legal obligation, duty, or liability that applies to others. So it's basically like you're in the code, but because the code gives you certain areas of the code that you don't have to do, you're not part of those other areas. So the word exempt and the word foreign are two very, very, very different terms. You have to understand that there's a huge difference between foreign and exempt. Exempt means, yeah, I'm a person in the tax code, but I'm a particular subclass of person or whatever that has certain outs within the code. Foreign is, I don't even know what you're talking about. I have nothing to do with any of that. That's not even under any sort of jurisdictional aspect of anything that I even need to deal with. Monstrous difference between foreign and exempt. With that said, you've got this W4 exempt. And it says here, I claim exemption from withholding and certify that I meet these various conditions. So you have to meet the conditions in order to be exempt. And this is why you're seeing these lock-in letters that people are getting in the sovereignty movement. Because you're not exempt, you're foreign if you are a white citizen of a state. Completely different class. So you have this big tax movement going on right now where everyone's going exempt. It's so easy. You just go in here and mark your W-4 and you go down to the bottom, and now they have a fucking checkbox. Before, there was no checkbox. You had to go and read the instructions, and the instructions said write the word exempt under 4C. So it was like the secret Mortal Kombat blood code hack from the 90s. But I guess people got pissed off about that at some point. So very recently, they decided to add in an actual box for the exemption that you can click. But really, that's all irrelevant. There are a lot of people that are doing this that are not getting in trouble. They're not getting lock-in letters and everything's working fine. I'm not telling you that's not true. That is very, very true, especially with the IRS being under as much stress and pain and attack as it's under right now. I don't even know how that's probably why they're doing these. I see these press releases of now they're working with Palantir and stuff, so like if they start working with Palantir, you're probably going to see a lot more of these like lock-in letters and stuff like that when people are doing these exemptions. So if you want to do the exemption, fine, I guess. It's up to you. I would never do one of these, but it's up to you. If you just want to try to get more cash in your paycheck tomorrow, it's super easy. A lot of people have HR logins, and you can just log in and just click the box and then hit OK, and then But that's not really what you are in most instances. What you actually are is you're foreign, which would be your W-8-BEN. Foreign status of beneficial owner. You are not do not use this form if you are not an individual. Instead, use form W-8-BENE. That's kind of interesting, right? You are a U.S. citizen or other U.S. person. You would use a W-9. See that? That one you wouldn't use because that's connected with the conduct of trade or business within the United States, which means working for public office within the District of Columbia. Receiving compensation for personal services performed in the District of Columbia. You wouldn't use that. You are not an individual. Let me take a look at this one real quick because you are not an individual. That's interesting, right? Oh, this is for entities. So the W8BENE is for entities. The sole prop is considered an individual. So if you're doing it for the sole prop, it would be a W8BEN. If you're doing it for some other foreign entity besides a sole prop, it would be the W8BENE. But there's also another one I'm going to show you as well. Yeah, I don't even know exactly how I'd fill this out anymore. I know in some previous videos I explained how I would fill this out, but let me see if I would maybe use this one instead. Yeah, this one has the treaty tax benefits. So this is typically where a lot of the W8BEN people fall down, is when they get down to the treaty section. I certify that the beneficial owner is a resident of. So if you're a white citizen of a state, you wouldn't be a resident, so you'd have to cross that out and put domicile. But the thing that makes all this so complicated is a white citizen of a state really shouldn't be filling out any of these forms. Even this form really wouldn't really apply to a white citizen of a state. So it's kind of a complicated situation, because in the previous 2.0, I told you how to fill out a W8BEN, right? The thing is that you really shouldn't even be filling this out. You really should just sue the employer. That's really the solution, because you really shouldn't be filling out any of these forms. They're all involving the District of Columbia, trade or business in the District of Columbia. The only way maybe you could fill out these forms, now that I've kind of come this far with it, is you do you set up a trust in your own nation, and then you would do a W8EXP on behalf of that trust. So name of organization, the Amnesty Coalition. You could make your own, whatever you want. Country of incorporation or organization, it would be Nation of the Amnesty Coalition. Type of entity, you could do foreign government, or if you wanted to create trusts underneath your own nation, those trusts could be international organizations. Those trusts could be private foundations, whatever you want. Chapter 4 status. You could do foreign government as per 18 U.S.C. 11. Permanent address is 123 Purple Monkey Lane. That would be in Pickletaria. Again, a lot of people will say, like, "Oh, you're just making this up. This isn't real." Yeah, but all of this isn't real. There's new street signs being put up for dirt roads all the time. All of us named all the different roads based off of presidents and all this kind of stuff. And then remember, what is naturalization for a legal fiction? 8 U.S.C. 1101 subsection A 23. The term naturalization means the conferring of nationality of a state upon a person after birth by any means whatsoever. So if I say Nation of the Amnesty Coalition and I say 123 Purple Monkey Lane, that's it. It says nothing here about has to be related to what? Google Maps? Even if that was, it would be like there's no law saying like what is the code or laws that show all of the legal information as regards to what an address is legally or not legally. That's all horseshit. Addresses are just fucking made up abstracts. So if I say under naturalization, if I say that I'm naturalizing this trust and this is what it is, then this is what it is. You're creating the nationality when you say this stuff. You don't put the address because it's there. It's there because you put the address. Do not use a P.O. box or other in care of address. See? Country, nation of the Amnesty Coalition. Mailing address. So if I wanted them to be able to send me mail, this is where I could use my P.O. box. If you want to send me mail, but that's not the naturalization location. The naturalization location is the permanent address. People are always like, why are there two addresses? One is a naturalization address. It's not there first and then you're putting where it's at. It's there because you're putting where it's at. This comes first. This establishes the fact that it's there. And that's why people are like, oh, the government's so suppressive and they're such pieces of shit and blah, blah, blah. No, they take whatever you give them. If you do 69, fuck you, faggot, Lane, that's the naturalization address for the trust that's being put on the form. Okay? Oh, we can't send, okay, you can't send me mail at this address? Where's the laws that say because you can't send me mail at this address, I can't put it on the form? I'm waiting. They do not want to have any of these conversations. They either don't know or they're absolutely terrified to start having these kinds of conversations with you. If they want to give you a hard time, the solution is you're going to make it very, very public, all of their communication. You're going to start posting it on social media. You're going to start suing them in major courts that create case law and precedent. And now their unwillingness to speak about the subject is going to expand by 100 times, and now they're really not going to want to talk about it. You see that? The country is California. That's a country, technically. USTIN. So you can get an EIN number. You'll see in the foreign entities, persons not required to file a U.S. tax return. I think I was covering this at the beginning and then I kind of spaced out, but it's okay. This is a good spot to go over it, right? Foreign corporations and individuals. Foreign to where? Foreign to United States, which they call only District of Columbia, but in reality it means any area under the exclusive territorial jurisdiction of Congress. Not engaged in a trade or business, which means public office in the United States, which means, as per their definition, District of Columbia, but like I said, I think it's actually 18 U.S.C. 5. And foreign partnerships, foreign trusts, and foreign estates that do not have gross income or is treated as... Now, they're not exempt. They're foreign. Everyone's running around wanting to be exempt, talking about exempt. That's not really what everyone in the sovereignty movement really wants. What they want is foreign. That's the big dog. That's what everyone is looking for. They just don't know it. Not exemptions. Okay. I have no exemptions. If I said I had an exemption, I'd be going to prison if it was under penalty of perjury. Effectively connected with the conduct of a trade or business, public office, are not required to obtain an EIN. Now check this out. Are not required to obtain an EIN unless they otherwise have United States source income on which the tax liability was not fully satisfied, right? So if you want to go to a bank account and open up a bank account without an EIN number, I've never seen anyone use this to try to get that done. But I've also looked at a lot of the policies and stuff like that they have, and they require an EIN. But having an EIN doesn't necessarily mean you're a taxpayer, because you can have some activities that would be, like if you had a defense contract with the U.S. government, and you also had a bunch of other stuff that was private defense or private sales of guns in multiple countries, that you have a trust or an entity or whatever, and part of it is involved with the trade or business in the United States, and part of it is not. So just because you have an EIN number does not mean that everything you do is now underneath the umbrella of taxpayer. It's just you can't pay the taxes without having an EIN number. Some of the activities that you do are underneath being a taxpayer, are underneath involved in public office in the District of Columbia. So the EIN would be used to pay the taxes on that portion. So I have EIN numbers for all my trusts, and I've never even filed a tax return because there's nothing that the trusts are doing that would not fall under this section. So if you want to go out and fight like hell, and hell, maybe use small claims or whatever to sue the banks to force them to allow you to open up trust accounts without an EIN number, that'd be pretty interesting. If anyone out there is doing that or if you've successfully done that, please contact me. That's very interesting. These are a lot of things that I haven't done because the effort to return ratio is not very high. Lots and lots and lots of effort, I presume, to get a bank account open without an EIN when having an EIN on my trust accounts has never harmed me or anyone else I've ever known. It's sort of like a lot of work to try to prevent something in the future that may happen that's never happened. Once I get far enough in the research, and once I start winning cases, I may get bored one day, and then now like this kind of stuff is all that's left for me. I'll probably get more involved in some of this stuff at that point. But to go off and spend a lot of my effort and my time in these kinds of areas, in my opinion, at this point in time, but there might be other people out there who want to take this torch and run with it because it sounds like fun. If I was listening to this video myself and I wasn't me, something like this would be very interesting. It's like clear. It's like very open. It's like you can just kind of run out. You can get a lot of great experience in small claims or whatever. It might be a great way for you to just get your feet wet and learn. And it's like, fuck it. Who cares if I don't get an EIN or if they force me to get an EIN? It's not going to make any difference in my life. It's got a low threat level to it. You know, this is the kind of stuff that you may want to do or try or just for fun or whatever. You just want to go out and just beat some ass, you know, whatever, right? So, but for me, it's low return, high work. So it's not something that I would be doing. But we do all sorts of 1, 2, 3 Purple Monkey Lane, Pickletaria, all this kind of stuff. And they're not giving us the 98 EINs. It's never been an issue. I say foreign on everything. I'm foreign everywhere, and no one's ever had an issue with it. So, you know, I'm not gonna go out of my way and try to do all this work for something that is just not all that important. Okay. So with that said, I would put a USTIN in here if the trust has one. If you have like this trust, the Nation of the Amnesty Coalition, this particular trust in my life doesn't have an EIN number and doesn't have a bank account. There are a bunch of trusts that were born out of this nation that have bank accounts and that have EIN numbers. There's also other sub-trusts that don't have any EIN numbers or bank accounts. And then the nation itself, the actual nation itself, does not have an EIN number or bank accounts. So I wouldn't put a TIN here. And if you say to yourself, well, Brandon, how would you put the Amnesty Coalition, and then they're going to put the Amnesty Coalition on the paychecks, you would endorse the back of. So the Amnesty Coalition is a trust. I'm the trustee. So let's say, for example, I have another trust that's called Brandon Joe Williams Trust. That one actually does have a bank account. So if I was going to do this and they were going to send me stuff, how would I endorse the back of the check? So the check says the Amnesty Coalition. There's no bank account or EIN associated with that person, but I am the trustee of that person. I'd roll it over, and on the back of the check, this is how I would endorse it without recourse. Pay to the order of, and then whoever I want the payee to be, and I could also do bearer. That would do a blank endorsement, and I could deposit it in any account. Doesn't matter. But if I wanted to be a little bit more careful about it, let's say there was an account. Let's say there's a sub-trust called Amnesty Coalition. You can name it whatever you want. Cash account. Cash trust. I don't know. We'll just name it that, right? By Brandon Joe Williams, trustee. Brandon, because the signature might be kind of hard to read, so it's then below that it would be the actual. So here it would be like this. So I'm the trustee of this of the payee, which is the Amnesty Coalition. The Amnesty Coalition does not have an EIN number or a bank account, so I'm going to then negotiate that instrument as the trustee into the trust person, which is a different trust, that actually does have an EIN number and a bank account, which is called Amnesty Coalition Cash Trust. You can name it whatever you want. You can call it I hate. I don't want to get banned off YouTube. So, you can name it whatever you want, okay? So, but this would be kind of how I would do it, just to keep everything organized, right? So there's two different trusts entirely. There's the Amnesty Coalition, which is totally foreign. There's no EIN. It's got no relationship with the U.S. at all. And then there was a trust born inside of that trust or nation called Amnesty Coalition Cash Trust. That trust has an EIN number, but I filled out the W8EXP on behalf of the mother organization. You see that? So this would actually be an A, and I would just privately negotiate the checks when I got them. You wouldn't be able to do direct deposit with this, but they'd be able to give you a check, and then the check would be able to be further negotiated by you with a pen. Do you see why they're trying to make everything direct deposit? So, let's see here. Foreign government within the meaning of Section 892, 26 U.S.C. 892. Let's see what this says. For purposes of this title, a foreign government shall be treated as a corporate resident of its country. A foreign government shall be so treated for purposes of any income tax treaty obligation in the United States. So it's treated as though it's not even here in the United States at all. You see that? I mean, you can read that more if you want, but I would just check that box. That sounds fantastic. And then that's it. I certify that I have the capacity to sign for the entity identified in line 1 of this form. I'm the only person, by the way, on the planet that can sign anything on behalf of this
person. There's nobody else on the planet. I'm the king. There's nobody else on the planet. So if you go sign in these documents and you click on this and you sign Amnesty Coalition, I will personally testify you in court and put your ass in prison. If you want to create your own nation, if you want to do your own thing, you can do your own thing. This whole video is just examples of how I would do it. And then you have to go out and do it for yourself. Sign here. The way that I would sign would be without prejudice, without recourse. Fuck it, why not? By Brandon Joe Williams, comma, King. My post title in relationship to this organization is King. I am the king of the Amnesty Coalition. And that bypasses all of the treaty issues that people normally have with the WABEN. See, a beneficial owner solely claiming foreign status or treaty benefits. There's a treaty section on the WABEN that trips people up pretty badly, and I've never really found a way around that. So if you want to get a job as a white citizen of a state, you can't really fill out any IRS form. The solution is just to tell them, I can't fill out any of your forms because I'm a white citizen of the state. You can use various documentation that I have. And if they don't want to do any of that, then you just sue them. You just sue them for discrimination. You sue them for whatever. I don't know. Forcing you. You have to commit a felony in order to work here. That's a lawsuit. Fuck you. Right? And like I said, if there's anybody who's going to run around and do that all over the place just for fun, please do contact me. That sounds absolutely wonderful. You are healing the world, my friend. Get everyone talking about this. Turn the knife. A lot of people are worried about tax returns in relation to getting, mortgages and stuff like that. So you have the 1040 form. Keep in mind the 1040 form is all about trade or business income in the United States. That's what all of this is asking. If you're not involved in public office in the District of Columbia and you're filling this out, as far as I'm concerned, you're committing perjury. You should be in prison. There's also the 1040NR. This is a non-resident alien who has income from a trade or business in the United States. You could just put zeros all the way down the whole page. If you're trying to get a loan, I don't really think you should even fill any of this stuff out. But if you really, really need to get a loan and you can't, I had a guy. If you're looking for a loan without using taxes, if you're trying to look for a loan without using taxes, I think I have a guy. That'd be another thing I could probably get a commission on. I mean, fuck it. I mean, it doesn't cost you anything. And I've done a lot of work to try to meet all these people and do all this stuff. So fuck it. It's like you can get what you want and I can get a commission. Fuck it. We all win. I don't see anything wrong with that. I don't think that's using this course in a way to try to coerce people or anything like that. There's just one guy, I would need to do a little bit more research on him. I may send people over to him, but I would kind of talk to you first and say, hey, I don't really know much about this guy. So kind of go in soft, But yeah, if you're looking for a loan, even a loan you're going to discharge, I don't give a fuck. But if you're looking for a loan without having to do all this tax stuff, just message me. I may have someone I can refer you to, and then I may get a commission on it. We'll see, maybe. But if not, if you need something fast or if you feel comfortable with it, I'm not so sure I feel comfortable with it, but you could do a 1040NR and then all the way down the page, you just be zeros. I've seen people do it and the IRS approves it and they send them back all the money they withheld throughout the whole year. For people that are currently having withholding and you just want to get back everything you've already paid in, you can do stuff like this. That's how I would do it. But then I don't think I'd keep doing it. You know what I mean? I mean, if you have a really, really, really high level corporate job and you don't want to rock the boat too much, I would probably just talk to them a little bit about doing some other solution like a W8EXP or something like that. At least to have evidence that you kind of tried to have the conversation. That way, if anything does happen in the future, at least you have the evidence that you did at least try to have the conversation. I don't know. Maybe that I would at least go that far if I were you. If you go to the frivolous tax position page on the IRS website, everything on there is all about taxpayer, taxpayer, taxpayer. Every single fucking sentence says the word taxpayer on it. So if you share with your friends and family, they're going to send you the frivolous tax positions. I can't even type it because it just irritates me. IRS. They're going to send you this page if you go around and talk to your friends and family about this subject. The word taxpayer, you have to actually go into the actual arguments, but the word taxpayer is, let's see if this is it, 107 times. Just on page 1. 107 times. Look at this. That's the secret. I'm telling you. That's the secret. That's the linchpin. You pull on that linchpin, all of this comes crashing down. Taxpayer means any person who is subject to any internal revenue tax. So they're saying someone subject to the tax is not a citizen of the United States and thus not subject to federal income tax laws. You see how clever the wording is when they use the word taxpayer? That's why all the letters that you get says, Dear Taxpayer, Dear Taxpayer. Taxpayer is the ultimate presumption from the IRS. And that's all you got to attack. Just tell the person that's sending you this page, the word taxpayer is defined at 26 U.S.C. 7701 subsection A14. I am not legally a taxpayer. If I told you I was, I'd be going to prison for perjury if I said it under penalty of perjury. So then they have to go through here and remove all 107 times that the word taxpayer is used just in this first section, and yeah, the whole thing crumbles. Very easy, right? But when you plug in the definition of the word taxpayer into everything they say, it's actually true, everything they say. It's like the ultimate word spells. Wizard, the wizardry. You know, the wizardry of the IRS is the word taxpayer. That is the wizard. There's a lot of other wizardry. You have trade or business, employee, United States, state, includes. I'm teaching you all the wizardry, but the ultimate wizardry, the one-shot kill for the wizardry is taxpayer. The sole proprietorship is a taxpayer. If you said the sole proprietorship's not a taxpayer under penalty of perjury, you'd have to know that it's not. You have to know that it is. But if I said my sole proprietorship was not a taxpayer, I'd be going to prison. If I said I am a taxpayer, I'd be going to prison. That's how I look at it. It's very simple. It's very simple, very clear. And I hope we can get you to that same level of clarity. Legal definition of franchise. A franchise may refer to the right granted by the government to a corporation to operate as a legal business entity. What is the state tax collector of California? The Franchise Tax Board. Residents and non-residents. See that? I'm neither. I'd be a non-resident. But it's domiciled, right? So they tell you straight up, right in California, that this involves franchises. The word franchise means, and you have to look it up in the legal dictionary, you'll find this definition. I'm just trying to speed this up because I don't want to go too much farther on this if I can avoid it. Refers to the right granted by the government to a corporation to operate as a legal business entity. A U.S. citizen. Same idea, right? That's very important. Franchise Tax Board. I am not a franchise. The sole proprietorship is a franchise. If I had a C Corp or an S Corp that was born or organized under the laws of the United States, that C Corp or S Corp or LLC would be a franchise. A foreign trust that's born in my country is not a franchise. 26 USC 641. Here's also from the tax code. Look at this one. This is the last piece of this puzzle that I wanted to show you. Computation and payment. This is under the application of tax section. And this is involving general rules for taxation of estates and trusts underneath Part 1, which is all about estates, trusts, and beneficiaries. Underneath Subchapter J, estates, trusts, beneficiaries, and decedents. And then normal taxes and surtaxes. So we are income taxes. So you have to kind of go back and look at all these subclasses to make sure you're not in some like really, really rare esoteric zone. So this is a very general zone. This is a great spot to find some information that applies to most situations. We're going to scroll down to subsection B. The taxable income of an estate or trust shall be computed in the same manner as in the case of an individual, except as otherwise provided in this part. The tax shall be computed on such taxable income and shall be paid by the fiduciary. And here's the bombshell. For the purposes of this subsection, a foreign trust or foreign estate shall be treated as a non-alien individual, non-resident alien individual who is not present in the United States at any time. So if I took one of my foreign trusts, this doesn't apply to California, by the way. This only applies to the District of Columbia. But I can take my foreign trust and go in and work with a defense contractor in the District of Columbia. And while that's happening, my foreign trust is still considered a non-resident alien even in that position. So, bet your accountant didn't know that one. Your fucking dumbass accountant. I fired all my accountants, fired all my lawyers. Long time ago. I didn't need that much retardation. I didn't need to pay to have retards around. If I wanted to do that, I would just volunteer at some one of these organizations that deals with, mentally challenged people. And then the last thing, and the most important thing I wanted to show you. So all of this is just kind of build you up, make you feel better, make you feel more solid, give you some confidence, take away some of the pain, some of the fear. And then now we're going to get into how to have IRS bills vanish with no effort. Okay. But before we do that, I'm going to take a little break here. We're going to pause here for a little break. Okay, we've got a refreshed cult leader here. Let's see if we can get through the rest of this. This is where this starts to get pretty interesting. So let's get into this. So you receive a bill from the IRS. We've already covered in previous videos. The bill is a bill of exchange. You have the IRS as the drawer. The drawee is either one of your corporations that you own, if you own any domestic trusts, if you own any estates, whatever it is, it's all got to be domestic. Typically, it's just your name in all caps. It's the sole proprietorship, so we'll just go with that for now. That's the drawee, and then the payee is the United States Treasury, right? So what you're going to do is I have a letter here that you're going to send in, and we're going to cover this in great detail. Let's see here, 8822B and cover letter. And then this one here, authorization for the campus to settle the account of the taxpayer. So right in the IRM, and you can look these up for yourself, there's this section, these two sections in the IRM. If a bill of exchange or registered bill of exchange is received from a taxpayer authorizing the campus to settle their account through Fedwire, now by this point in the course, this sounds like the craziest sentence in the world, but it really should make sense to you. If a bill of exchange, which also means bill, which also means draft, which also means unconditional order to pay, all of that is the same term, or I don't even think you really even need to know this, registered. Registered is like when you look on a Federal Reserve note, it's got the serial number. It's like registered to like the original owner. I don't really know where those registrations go. The SEC, I don't really know where they go. But anyways, registered bill of exchange, not really something you're going to need to worry about. Is received from a taxpayer. Who's the taxpayer? It's not you. It's a sole prop when it's your name. Authorizing. So what are you doing with this? You're authorizing. The word campus took me a while to figure out. I had to use AI to figure this out. Campus is like one of the main IRS processing centers. So for whatever reason, they tried to make this as complicated as they possibly could so that people wouldn't really see it. To settle their account through Fedwire. Fedwire is where you can go to swap negotiable instruments. I think it's what connects to the Federal Reserve discount window or something like it, something similar to it. Send everything to the following address. So for the longest time, between 2.0 and 3.0, I had people just send straight to the Treasury. But then, I started getting more bills, and some people started getting more bills, some people didn't. It took them a year. So I decided I was going to change the process a little bit just before I did the 3.0 course. And we're sending this to the IRS to then follow this and to forward it to the Treasury on our behalf. A little bit different. I think it'll fix the few little issues that we did have. I hereby authorize the campus to settle the account of the taxpayer, which isn't me, using the draft, unconditional order to pay, bill of exchange, all the same term, you have sent by using Fedwire or any other swapping/discount service. Let's take a moment and thank you for the service of which you offer to settle the account of my disregarded entity, which is saying the same thing as sole proprietorship, on my behalf using Fedwire. Enclosed in this envelope are the original bills of exchange, bills, unconditional orders to pay, drafts, all the same terminology, sent specifically to the sole proprietorship/individual named, quote, Brandon Williams, end quote, in all caps, which is a DBA for the full name with the registered trademark. Me, as a white citizen of the state, I just spell it differently here, is not the drawee, drawer, or acceptor, and is hereby, because you'll see you can't endorse if you are the drawee, drawer, or acceptor. That's part of the definition of endorsement. So I just specify that I'm not those things. And I'm hereby negotiating these unconditional orders to pay back to you to allow you to become the holder in due course of the instruments, which is just an upgraded version of a holder. You can just say holder. I know there's a lot of stuff online, HDA, HDI, DDC, and then just big complicated processes on how you do the holder in due course stuff. It's all horse shit. All of it's horse shit. Holder in due course is (3-302), and holder in due course is just an upgraded version of a holder under certain circumstances. If the instrument was, when issued or negotiated to the holder, does not bear any sort of evidence of forgery or alteration, so there doesn't seem to be any weirdness or goofiness kind of going on to call into question its authenticity, and you took the instrument for value in good faith. This is where the whole accepted for value thing came from. Yeah, fine. It's one itty bitty, teeny tiny little thing that really doesn't mean shit. As far as I can tell, it just means that you're not taking the instrument partially or splitting up the instrument with other people or securitizing or collateralizing and splitting it up, which you guys aren't going to be doing. No one's going to be doing that. You don't need all that. That's like advanced banking. Like if you're doing like an IPO or something, an initial public offering, maybe you would be doing something like this. It's not important. It's not that important. In good faith, blah, 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 without any dishonor, blah, 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 blah. So holder in due course is just an upgraded version of a holder. It's not that important, and people have created these whole huge, massive things, processes that go on and on and on that you can't make any sense of. That's all just confusion. You have a holder, and then if everything looks good and everything was accepted wholly and it wasn't split up and it doesn't look like it was forged, it's holder in due course. Slightly, it's a better position. It's a better type of holder. It's like holder and super holder. And I have that on the flow chart. It's just an upgraded holder or super holder. Keep it simple, guys. It's already complex enough as it is, okay? For you to become the holder in due course of the instruments, please find the enclosed drafts / bills, same word, of exchange, all endorsed. So real quick, INDORSED is the same as ENDORSED. I just like the IN because that's how it was originally used in UCC Article 3. I did a lot of research on this. It took me a long time to figure it out. The IN versus the EN is just a change in language. And you don't know how I found out about that? When I was rewriting the 1928 manual, my book, a lot of the way that the words were spelled just in general, like the word insure, was spelled with EN rather than IN. And it was through the whole manual. And that's when I did a huge deep dive on that. And I go, is this it? Have I finally found this? And then I found out that it was just a change in language that happened in the 1920s, 1930s that caused that shift to take place. So EN endorsement and IN endorsement in some of the old videos that I did, I used to think like IN was for the front of the instrument, EN was for the back of the instrument. That's all false. It's the same thing. There's no difference between the EN and the IN. And it just kind of goes to show you how much work has gone into trying to understand all this stuff. So stuff like that, a year or 2 years ago, I didn't know, or I told you something I thought I knew, or whatever. And so it just shows you every single word, every single thing. We just have to put it together brick by brick, piece by piece, right? All endorsed with qualified and special endorsements for accord and satisfaction. Remember that? Accord and satisfaction by use of instrument, 3-301. And then since this is a federal matter, because the IRS is a federal agency dealing with a federal matter, we're going to use, as per 4 U.S.C. 72, we're going to use the code of the District of Columbia. And it's the UCC section in that code 3-301, because the UCC is not law, it's a model code. And then this is the big change that I made before 3.0. It's not a big change, but it's a change. Please make a note in your computer system that this authorization and payment have been received, and then forward everything to the Treasury to be processed on Fedwire. I would also appreciate to be sent a receipt once this payment has been processed, so I know these instructions were accepted and not dishonored. Thank you for your assistance. And you can see here, parcel is from a white citizen of California who is not a citizen or resident of the United States. And he's the beneficial owner of sole proprietorship named this. And then this is the social security number for that. This is the taxpayer identifying number of the disregarded entity. You see that? And then I just put beneficial owner. If you remember from the constitutional versus 14th Amendment flowchart, you have the definition of owner, and it could be either trustee or beneficiary, depending on the situation. Sometimes you want to be specific, sometimes you don't. I just thought it'd be better to be more specific on this particular, because our relationship is I'm the beneficial owner of the sole proprietorship. So that's why I put beneficial owner. But you can just put owner. That's fine. they're not going to ask any questions. They don't want to talk about anything on this form at all. They'd rather die than talk about literally anything on this paper. So don't worry about it. People are so worried about it. I was too, until 2 years later, I couldn't get anyone to talk to me, and then I finally woke up and realized, why am I upset? This is fantastic. They don't want to talk to me. This is the best thing that ever happened. And then here we are in 3.0. So you're going to take your original bills and you're just going to write this endorsement on the face of the instrument. And the reason why I wouldn't do bearer is because they tell you right on the bill of exchange to make the payment out to U.S. Treasury or United States Treasury. If it says United States Treasury, you may want to actually just write out exactly how they have it on your bill. If it says U.S. Treasury, you can do it this way. If it says United States Treasury, you can write it out. It's not really going to make that much of a difference, but I probably would write exactly the way they have it spelled on the bill of exchange, the payee of the bill of exchange. And you're going to send that in. I sent all of that directly to the Treasury. I didn't hear back. So I sent all of that on December 3rd of 2024. And then shockingly, I heard back. I got another bill in March of 26. So a year and 4 months later, I got another bill. And this is and I was kind of preparing for 3.0 at this time as well. So I wrote this response letter. And no one's allowed to use the Williams & Williams Law Group logo except me. You can use the Amnesty Coalition logo, though. That I allow you guys to use, but you can't use the Williams & Williams, okay? White citizen of California, non-citizen, non-resident of the United States, on behalf of the taxpayer, which is the sole proprietorship disregarded entity, right? Dear Internal Revenue Service employee, thank you for your draft or unconditional order to pay or bill of exchange. I'm going to keep doing that until you guys realize it's all the same stuff. My name is Brandon Joe Williams, and I am the owner of the taxpayer listed on the bill of exchange draft unconditional order to pay bill you have sent. I have enclosed the original bill of exchange you sent me with the term non-negotiable written across it in red ink due to the fact that the previous bills of exchange have already been tendered directly to the U.S. Treasury for accord and satisfaction in accordance with the Code of the District of Columbia 3-101, accord and satisfaction by use of instrument. I have already authorized the campus to settle the account of the taxpayer using the previous bills of exchange that are to be processed on Fedwire in accordance with the IRM sections regarding the unconditional orders to pay that were sent to the taxpayer back in November of 2024. I will attach the original mailing as Exhibit A that went straight to the U.S. Treasury, but I will write non-negotiable across the face of the instruments in red ink as these are just copies and are not in themselves negotiable. They don't themselves have value because it's already a done deal. I think the problem is here, and this is kind of where I made this adjustment. I think the problem here is that I sent the authorization and endorsed bills of exchange directly to the U.S. Treasury rather than to you first to forward to the U.S. Treasury. I apologize for that. You may have never been informed this took place. This debt has already been handled quite some time ago. You will need to contact Rachel Miller, the current sitting executive secretary of the United States Treasury, to confirm that these debts were settled via Fedwire. I believe there was a different sitting executive secretary when these bills of exchange were originally sent in. You can contact Rachel Miller at phone number. The taxpayer, meaning the sole prop, meaning the disregarded entity, meaning the individual. I'm also not an individual. The taxpayer does not hold any assets. I don't have any bank accounts. I shut down all of his bank accounts. I took his name off all certs of title. My car is not under his name. Nothing's under his name. So he does not have any assets. He does not have any wages, and he is not a natural person. Natural person is a man, woman, or child with rights or obligations under the 14th Amendment. He is not a man, woman, or child. So that's the definition of natural person. I am not a natural person. I am not a man, woman, or child with rights and obligations of the 14th Amendment. I am a white citizen of California, which is not a natural person. Okay? Natural person is a 14th Amendment term. He has no bank account, holds no certificate of title or any other assets, meaning the sole prop, meaning the disregarded entity, meaning the individual. He does not have any income and is only used to manufacture unconditional promises and orders to pay in accordance with the District of Columbia Code definition of a negotiable instrument and in accordance with 18 U.S.C. 8 obligations or other securities of the United States. And the reason why is because every time I use my credit card, the sole prop is manufacturing an unconditional promise to pay. So I use him to manufacture unconditional promises and orders to pay. You see that? I'm not sure if I can be any more assistance on this, but you're welcome to contact me if you would like. I have a durable power of attorney between myself and the taxpayer if you need that, but beyond that, I'm not sure I can be much help at this point. If you want to see my durable power of attorney, you can go to williamsandwilliamslawfirm.com. You can go to About. You can scroll down, and you can find my USPTO page for my trademark. If you want to copy a lot of the ways that I did my trademark and you want to do it yourself, you can just go on here and you can just steal all of the way that I did everything. That's how Joe Lustig did it. Just come on here and just look through here and just take everything that I did. I had a guy help me. So if you want to just come through here and just copy everything and then do your own that way, you can save and not have to hire anyone or have to hire my guy. I know in a previous video I said you can hire my guy, but you can just take my shit and do it yourself if you want to save the money, the notes. This is we're not going to get into the UCC1 stuff right now. UCC1, let's see. I don't have that listed actually anywhere here. A UCC1 is, a UCC1 financing statement is just so you promise me, like I loan you money, and then you place something as collateral on that loan. Let's say a motorcycle or jewelry or whatever. A UCC1 is just a public announcement that there's been collateralized for a loan. And there's so much information about this online. It's part of all these different really complicated processes. It's not that important. I've never really seen a UCC1 be all that important. It's nice to have one, I suppose. For me, the debtor name is the sole prop. The secured party is Brandon Joe Williams Trust. Mailing address is just American Samoa because I didn't know what else to do because I don't give a fuck. And then I just wrote everything in here. My cars, my book, my intellectual property. This is all in an effort to just have evidence that the sole proprietorship literally owns and controls nothing. I mean, have I ever used this? No. Could it be part of the reason why I'm never touched or sued or bothered? I don't know. It takes 5 minutes and $5 to file one of these. And there's a lot of people who do this on judges and stuff like that. That is the fastest way to get into a lot of trouble in the sovereignty space. To tell you the truth, there's not really hardly anything in the sovereignty space that you can get into much trouble with. Shockingly, originally I thought people were going to be getting into a lot more trouble. The only thing really that can get people into a lot of trouble that I've ever seen people get into a lot of trouble with is using these UCC1s and just filing them on people kind of randomly or as an attack. I do not recommend that you do that. That is the one thing. So if you are kind of skittish about all this information and you are fearful and you're not sure where to start, do not start here. This is the last thing you should be dealing with if you're scared about getting in trouble. This is pretty much the only thing, in my opinion, anywhere, as long as you're truthful and don't lie under penalty of perjury, that you can get yourself into some trouble. If you want to use it in a simple way, you just do it on yourself somehow. Create a foreign trust, and then put everything down as collateral for the sole prop into the foreign trust. That's the only reason why I've ever used one. I've never used one for any other reason. If you wanted to start creating your own currencies with your friends can unconditionally promise to pay you $100,000. They can put their car up as collateral, and then you can go file UCC1s. and then you can actually send that promissory note in as a payment, and you can attach the UCC1 to the payment to give it like extra reality. And then if they ignore the payment, then you would file all that into your case. I suppose you can do stuff like that, but like I said, I wouldn't recommend that you really use these except either with yourself, your sole prop, your own businesses, or with your friends. You shouldn't just be doing this on random people, especially judges, stuff like that. You can get yourself into some serious trouble with that. But all in all, it's not that important. There's a lot of people teaching all about UCC1s, but I've never even used it. But $5 in 5 minutes, I'm sure it has some value. Okay, here is my durable power of attorney, and if I ever make new ones later, I will post the new links here. Here's the durable power of attorney, and then I also have on the resources and documents page, I have the durable power of attorney between you and your sole prop. I have an actual editable text file for you. You just download this, and then you can edit it yourself. And if you want to compare it to the one that I have here, this is the final version that I have here. Again, you're not allowed to use the Williams & Williams Law Group logo for any reason, but you're more than welcome to use the Amnesty Coalition logo if you are an ambassador. To be an ambassador, you have to follow the code of a Pickeltarian. The code of an ambassador, you have to have the covenant of an ambassador, you have to have read my book. There's some rules on that. But any ambassador of the Amnesty Coalition is allowed to use our coat of arms for their documents. Okay. And then the 8822B, I'm not sure we even need this anymore. I'm not sure if it's effective because I sent mine in and I still got a bill like a year and a half later. But so this is still a little bit in the discovery experimental phase, but this is just a permanent authorization and change of address for the authorization for the campus to settle the account of the taxpayer using a bill of exchange or registered bill of exchange that is processed on Fedwire. I will show you what an 8822B looks like. It's just change of address. So you're going to handwrite the social security number here, or you can just write it in and make it look like an EIN number because it's the same amount of numbers. Business name, Brandon Joe Williams. It is a business. You're just changing the location. And then just like it says in the authorization. Remember the authorization? Here it says if a bill of exchange, registered bill of exchange is received from a taxpayer authorizing the campus, and then it has this is the person who processes that. The 8822B is just a permanent address change, so they can send all new bills to that person. But again, I sent this in and still got a bill like a year and a quarter later. So this particular item is still in the works in terms of maybe we may need to shift some things, change some things on this. I don't really know. I never heard back on this. I was never told this was wrong or incorrect, but yet I still got a bill a year and a quarter later. So you can send this in. It's not going to hurt anything, but just keep in mind you may still get a bill afterward, and that's where I sent in, but it was like an older version of everything that I sent in. So it's kind of hard too. It's like we have all newer versions now. Things are done a little bit differently. So like now I have to wait and get more information from people or kind of see how they react before I'm going to issue any more information on the subject. So we have like tests, and then we send stuff in, and then test, and then send stuff in, and then test, and then send stuff in, right? But the last thing that I sent in was this letter I just showed you, this one here. It'd be smart to create your own law firm if you want to. You can do that, and then you can create your own logo, and then you would have your own You could even do it kind of like how I do it. Let's say your last name is Gibson. You can have Gibson and Gibson, all caps, law group. You can do whatever you want. You just can't use this, right? So if you want to do that, usually from my experience, the reason why I do that is because when they receive anything that has a law firm at the top, they don't really even read it. They just forward it to legal. So if you want them to just forward it to legal, it's smart to have your own law firm to do that with, right? So yeah, the 8822B is still in the works. That is, but all this other stuff and the endorsement and sending everything back and getting all that, I'm really pleased with the way that I changed it to where now you're going to send it to the IRS for them to forward to the Treasury. I think that's going to actually work better. You can see all the different changes and releases. I made that change just very recently, like 2 weeks ago, because I was preparing for 3.0 and I just wanted to make that little adjustment. I think it would help. So that's how you get IRS bills to just simply vanish without having to pay them. You endorse them. You authorize them to settle the account of the taxpayer using the bill of exchange itself. You endorse the bill of exchange so that they can become the holder and so they can transfer it. And then you're going to send it back. If there's an original copy of a bill, you're going to send them back the original. When you send back the original, you're going to use registered mail. But if you're not sending originals of bills, if you're sending copies of bills or letters, or you're responding to one of their letters, you can use certified mail. Registered mail is specifically one of the purposes for sending registered mail, is for when you're sending originals of valuable documents. So I would send the originals back registered mail. I know in like 2.0, I went into like how to do registered mail and stuff. I suppose I could go into that for just a moment. Certified mail 88, what is it? 8822, is that? Certified mail green card. A lot of the stuff isn't really as important as I thought it was. So it's kind of random. I'm doing this on a tax. It makes sense for the tax video, I suppose, though, because I think it was like a whole separate video before, which is super dumb. So you're going to get a stack of these from the Postal Service. You can even order them. This has the tracking number on it, the certified tracking number, and then they'll tear all this off and stick it on the thing for you. And then you're going to fill out one of these to go with it. You're gonna fill in the little box adult signature. You're going to fill in the little box certified mail or registered mail if you're doing registered mail, and then you're going to fill in the little box signature confirmation. And you're going to spend a little extra money, and then you're going to get this back, the actual physical card back, signed by the person. But I taught that in 2.0, but it's just not that important, because when you get into litigation and stuff like that, all I've been doing in my litigation, you'll see it in the videos, is I just print or save to PDF the USPS. I just go to USPS.com, I type in the certified mail number, I hit it, and then I just print that, and I've never had any issues. So I've never had any bar cards pretend as though they never got it. I've never had any so do you need this signed thing? Yeah, it can help, I suppose. But again, I think it's kind of overkill. I hadn't done enough litigation to really know. So I'm not going to get into some huge detail as to how to fill these out. That's all I'm going to give you on this. Just those 3 boxes. Article address 2, you put the 2 address there, you flip it over, you put the where your address is, it's going to come back to. They sign it, it gets torn off, and then it gets sent back to the address in the back of the card. If you want to do a couple for fun, send your friend one. You can even send yourself one, and you'll get it. You can kind of experience what it's like to receive one, and then that's it. We're not going to get into that in some great detail like we did before. Registered mail is the same, but you're going to fill out one of these green cards, and then you're also going to fill out a separate white card. It's kind of a pain in the ass. You have to fill out multiple things. But if you're doing certified mail, this is all you need, just these 2 items. and you can take a stack of these home, and you can take a stack of these home. And just do it a couple times, and you'll experience it. I'm not going to try to go into some huge explanation as to how it all works. Just go send a couple, and you'll see it all. You'll see the way they build it. You'll see everything. It's very, very simple if you just do a couple. Don't try to understand everything before you go. Just go and send one to yourself or something. I don't know. Okay? The whole reason for this is just to have evidence that they receive stuff. That's it. That's all you want. Okay? Okay, guys, that's it on the tax video. That's all we're going to cover. That's all you're going to need. And I hope you guys loved it. Let me just double check and make sure everything is covered. I think we've covered everything that I wanted to cover on this. This is a very thorough, much, much better than the 2.0 course because we already have covered negotiable instruments. Negotiable instruments is by far the most important aspect of taxes and taxation handling. So this is way better than 2.0. I mean, all these videos are 1,000 times better than 2.0. It just shows how far we've come in 2 years. So, all right, guys, I will see you at video number 6. See you later.